A very straightforward, to the point title. If I could click my fingers and change one thing about the criminal law, I would decriminalise prostitution. And in this short presentation, I'm going to give you an overview of why and how. So the existing legislative framework regulating prostitution in England and Wales is piecemeal. It lacks a coherent rationale. Whilst neither selling or paying for sex is in itself illegal, a range of associated activities, including soliciting, brothel keeping, and controlling prostitution, are criminalised. And these prohibitions are scattered through a range of statutes. They've been introduced in different time periods, and they reflect a variety of different ideologies. So some of this legislation was originally introduced to promote morality or to control disease, or uphold the respectability of public spaces. And more recent reforms have tended to emphasise sexual exploitation and gender equality. So we don't have a coherent framework of legislation in this area. And because of that, the need for reform is widely recognised. But the direction that such reform should take is hotly contested. And broadly speaking, those calls for reform tend to fall into the two following categories. So if we take the sex buyer law first, so advocates of the sex buyer law, also known as the Nordic model or Swedish model, primarily view sex work as a form of violence against women, which should be abolished. They therefore argue for the criminalisation of sex buyers in the belief that this will end demand for prostitution and that prostitution will thereby be eradicated. By contrast, advocates of decriminalisation, myself included, generally frame the practice of selling sex as sex work. As a form of labour, sex work carries risks of harm and exploitation, as do many other types of work. And as such, the aim of any regulation of the sex industry should be to reduce this harm and exploitation. And that is best achieved through labour law and the strengthening of sex workers' rights, rather than through criminal prohibition. Now, there is some common ground here. Crucially, both of these approaches agree that sex workers, or prostituted women as they're often referred to by advocates of the sex buyer law, should not be penalised for selling sex, but rather they should be protected against harm, violence, and exploitation. So the disagreement is really about how best to achieve that goal. And my argument, as I've said, is that that goal is best achieved through decriminalisation, and that criminal prohibition, even those offences that appear to be aimed at curbing exploitation by clients or by third parties, in practice put sex workers at increased risk of harm, of social isolation and poverty. So in the remainder of this paper, I identify the key existing criminal offences, highlighting some specific reforms that I think should be put in place. So if I start with the laws directly targeting sex workers, the primary existing offence is that of soliciting for the purposes of prostitution under Section 1 of the Street Offences Act 1959. And this section provides that it shall be an offence for a person aged 18 or over, whether male or female, persistently to loiter or solicit in a street or public place for the purpose of prostitution. This offence has its roots in a liberal legal framework, which essentially says that the activities of consenting adults in private are not the state's business, but that activities conducted in public places, such as street prostitution, can be prohibited on the basis that they constitute a public nuisance. So this offence was originally designed to penalise sex workers themselves for engaging in inappropriate and immoral behaviour in a public place. Now, the offence has been amended several times, particularly over the last sort of 2 decades. And perhaps most significantly, enforcement and support orders have been introduced as an alternative to traditional forms of criminal punishment. And changes like this represent a transition from a logic of penalising sex workers for creating a public nuisance to a logic of criminalising adult sex workers for their own good. So the underlying ideology has changed, but the sex workers are still criminalised at the end of the day. And it won't surprise you to hear that I don't believe the criminalisation of soliciting is good for sex workers. It doesn't help to alleviate exploitation or violence against them, and can instead increase the risks of these and other harms, as street-based sex workers take evasive measures to avoid the threat of criminalisation and sacrifice other safety precautions in order to do so. So in practice, that means things like working in more secluded areas or locations they're less familiar with, and spending less time vetting clients in order to reduce the risks of getting caught. In addition, sex workers who are victims of crimes such as rape, assault, and robbery are often reluctant to report these crimes to the police, fearing that they will not be taken seriously. And this is unfortunately borne out by the experience of those sex workers who do report and then feel let down by the criminal justice system. And violent individuals know this and weaponize sex workers' reluctance to out themselves to the authorities in order to attack them with impunity. Fear of criminalisation also makes it harder for sex workers to engage with health services, as it disincentivises them from talking frankly about their circumstances and their health needs. And moreover, the ongoing stress of potential arrest and identification should be understood as a harm in and of itself. Now, as I mentioned a moment ago, sex workers who are caught and convicted of soliciting can be given an ESO, which requires them to attend 3 meetings with a court-appointed supervisor in order to address the causes of their offending and find ways to cease engaging in this conduct in the future. Now, from the sex worker perspective, that is at least better than being sentenced to a fine. And in practice, the ESOs often amount to the continuation of support from a service that the sex worker was already engaged with. And they can also sometimes facilitate contact with sex workers who were not previously engaged with support services. But if street-based sex workers weren't being criminalised and displaced from well-known red light areas in the first place, it would be easier for support and outreach organisations to engage with them. So while the support provided under the guise of ESOs can be beneficial, it's compromised by being bound up with criminalisation. And of course, this kind of individualised support will only ever have a limited effect if the social and structural issues, austerity, poverty, discrimination, which push people into prostitution, are not addressed themselves. And we mustn't forget that despite the introduction of the ESOs, a range of punitive sanctions remain available. These include community protection notices and criminal behaviour orders, which can be used, for example, to ban a sex worker from the area where she usually solicits, thus pushing her potentially into more dangerous areas. And fines, which serve only to punish poverty and incentivise sex workers to continue working in order to pay them off. And in any case, whichever type of sentence is given, a criminal conviction for soliciting makes it harder to access mainstream employment and housing, thus further entrapping sex workers into prostitution. I therefore argue that the offence of soliciting should be repealed, and in line with the recommendations of the Home Affairs Committee on Prostitution, that the Rehabilitation of Offenders Act should be amended so that previous convictions for prostitution can be deleted. Moving on then, there's a further set of offences designed to target commercial sexual exploitation. But in practice, the broad interpretation of some of these provisions and the enforcement practices that they give rise to mean that these can also end up penalising and harming sex workers themselves. Those in most urgent need of reform are the brothel keeping offences under the Sexual Offences Act 1956. And essentially, this means that premises used by at least 2 sex workers for the purposes of prostitution qualify as a brothel. So where 2 or more sex workers operate from the same premises, they are all potentially liable for brothel keeping. So these offences discourage sex workers from working together indoors, despite the fact that working with others can be a means of enhancing physical safety, social engagement, sharing advice, saving money, just generally having other people around to kind of vent and deal with your day at work. So as with soliciting, these offences have an adverse effect on sex workers' safety and well-being. And in addition to sex workers, other third parties such as receptionists or security working in so-called brothels can also be subject to liability. One particularly egregious example is the case of Christy Norman, a 70-year-old woman who was working for £6 an hour as a cleaner in a brothel. When a client collapsed, Norman administered CPR, stayed with him until the paramedics arrived, and was subsequently convicted of assisting in the management of a brothel for her troubles. Similarly, the offence of controlling prostitution for gain has been interpreted broadly enough that it could be applied to sex workers who make appointments for each other and record each other's appointments in a diary, or people working as brothel receptionists. And these really aren't the kind of exploitative and controlling quote unquote pimps who the legislation, in theory at least, was aimed at. The existence of these offences also means that sex workers in brothels live with the constant threat of police raids. Rather than protecting sex workers from exploitation, such raids result in a number of adverse effects, including the confiscation of sex workers' income as proceeds of crime, the removal of their children, the deportation of migrant sex workers, and the general stress and humiliation of being dragged out of one's place of work, sometimes partially clothed in view of cameras and crowds. Such raids appear to do little to actually protect sex workers from exploitation or punish abusive managers. Instead, the criminalisation of brothels means sex workers lack formal employment rights. And so if they're treated poorly by managers, their only options really are to put up with it or seek work elsewhere. So finally, if we come to laws targeting buyers, at present, England and Wales has no general prohibition on paying for sex. It does, however, prohibit clients soliciting sex workers in public places and also paying for sexual services of a person subject to any level of force, threats, coercion, or any form of deception. The latter is a relatively broad offence, so it doesn't require any knowledge or intention on the part of the buyer, and it doesn't require a lack of consent, just some minimal form of coercion or any of those other categories. And the maximum penalty for someone convicted is a fine. So the offence is both overly broad and yet not serious enough to really capture the gravity of forced prostitution. And in practice, there are very few prosecutions for this offence. So I argue that both these existing offences relating to buyers are ineffective and should be repealed. And moreover, the frequent calls for universal criminalisation of buyers should be resisted on the basis that these laws cause substantial harm to people who sell sex, whether by choice or due to coercion. As with the offences I've already discussed, they compromise sex workers' safety. Street-based sex workers are pushed to more secluded areas and have to vet clients more quickly to shield them from criminalisation, while indoor workers find it harder to share information about abusive clients when clients are fearful of giving their names or any identifying information. And I think efforts to protect sex workers by criminalising their clients fundamentally misunderstand the operation of power within these transactions. Sex workers need clients' money more than clients need, or rather want, sex. Thus, the burdens of criminalisation are simply passed from the client to the sex worker, who has to take additional steps to absorb that risk on the client's behalf. To the extent that sex buyer laws do succeed in their stated aim of discouraging clients, this decreases sex workers' available income, and in the absence of better employment options, that doesn't incentivize them to exit prostitution, but rather to drop their prices, engage in riskier sexual acts, and become more reliant on managers in order to compete for a decreased pool of clients. There's also no evidence that these kinds of laws have decreased sex work in Sweden, where they were first introduced, or that they would do so here, because the existence of clients isn't what drives people to sell sex. It's the costs of basic survival, care of dependents, education, and the lack of better alternative sources of income, particularly for disabled people, trans women, and other marginalised groups. It's this economic need that primarily motivates individuals to engage in sex work. So rather than introducing further criminalisation of aspects of the sex industry, I believe the best way to protect the most vulnerable sex workers is through full decriminalisation of the purchase and sale of sex. Crucially, decriminalisation is distinct from legalisation models, as in Germany and the Netherlands, where sex work is legal and heavily regulated in specific circumstances, but otherwise criminalised. Instead, New Zealand's Prostitution Reform Act provides a model for decriminalisation which could be followed in England and Wales. Under this act, up to 4 sex workers can legally work together without any form of licence or registration. Where larger numbers work from the same premises, this requires an operator certificate, though licensing is relatively light touch. So this system grants sex workers greater autonomy over where and how they work. If they're working for themselves, they can work alongside others for safety, companionship, to share costs and administration. And if they're employed by third parties, they're protected by labour laws, including health and safety legislation and laws against harassment in the workplace. And indeed, at least one New Zealand sex worker has successfully sued her manager for sexual harassment. Decriminalisation also reduces sex workers to distrust of the police, better enabling them to report violence or exploitation of minors, and so empowers them in their relationships with clients and managers who can't use that threat of criminalisation over them. So, to conclude then, this approach should inform law reform in England and Wales. The majority of sex workers in this jurisdiction, as in New Zealand, sell sex to avoid poverty, not because they've been kidnapped or forced by individual boogeymen. In their encounters with clients, sex workers make meaningful distinctions between those who act in accordance with what has been agreed and those who commit rape or other acts of violence. Exploitative managers and clients do exist, but attempts to address this via blanket criminalisation fail to protect sex workers and instead obscure the systemic problems of poverty and discrimination which lead people into sex work in the first place. Worse still, they actively cause harm to sex workers, as I've illustrated. I therefore advocate the full decriminalisation of prostitution, most urgently the repeal of the soliciting and brothel keeping offences. And crucially, the views and voices of current sex workers should be central in shaping any programme of law reform in this area. Thank you.